Professor Julian Rivers, could you just tell us a bit about yourself and who you are?
Yes, I'm an academic at the University of Bristol.
Brothers?
Sorry, is that, yes, I
Carry
continue?
on, please.
I've been teaching legal theory and public law at the University of Bristol for 20 years, and I've written quite extensively on the legal regulation of religious organisations and questions of religious liberty, religious equality, and human rights generally.
Mr. Burrows.
We've had to talk about a religious view of marriage. I'd like to ask you whether you think there is a proper social view of marriage as a social institution, and how you see that meaning defined and its purpose.
I think the situation we're in is we're seeing a conflict between two fundamentally different social views of marriage, and it reflects a debate that has been going on for at least 150 years. It's just that right now we're in the middle of a head-on collision between those two views. Obviously, the institution of marriage has changed quite considerably down the centuries, but the older view, in its essence, tries to construct an understanding of marriage that is responsive to biological fact, what it takes to be true about the natural world. And that, of course, that process of construction has been going on for over 1,000 years. What we see arriving in about the mid-19th century is what we could call a romantic view of marriage, where marriage is fundamentally about the expression of love of two people for each other. And that is a view then which, in some sense, floats more freely above what is taken to be the natural givens of biological reproduction and of gender difference. Now, as I said, that debate has been going on for an awfully long time. And I think the difficulty is there that we, towards the end of the 20th century, for some very interesting cultural reasons, found ourselves in a position in which the idea that ethics is grounded in nature becomes less and less plausible. And the idea that our ethics is fundamentally an expression of individual will and construction, our individual autonomy, becomes more and more plausible. And so in every society within the Western world, we're seeing the societies reaching a tipping point at which suddenly the older traditional view of marriage comes to seem unacceptably limited, potentially even oppressive. And the romantic view of marriage, in which marriage is fundamentally about an expression of love of two people for each other and commitment to each other, comes to seem normal and appropriate. And once that tipping point happens, all the language of discrimination and equality cuts in. So if you take the slightly older, considerably older, more, shall we say, biological view of marriage, it's not discriminatory for two people of the same sex not to be able to get married. They just can't get married. It's not what marriage is. Their relationship is something different. It might be perfectly good, it might be valuable and valid, but it's not a marriage. There's a category error being made there. But once societies tip over into accepting the romantic view of marriage, the argument from discrimination is obvious. Of course it's discriminatory to exclude two people of the same sex from such a view of marriage, because of course two people of the same sex may love each other and can commit to each other. So I think we're just right in the middle of that tipping point here in the UK. Other countries, of course, will hit that at different points. Some have been there already. Many others, no doubt, will come to that. And the fundamental question that I think we need to face is, how do we live with our difference? How do we live with the fact that we have these two conceptions of marriage knocking around our culture? Are we going to try and simply enforce one to the exclusion of the other? Or are we going to try and make space for both? My own view is that neither will go away. Neither will go away. We cannot assume that in a generation's time nobody anymore will hold the slightly older, more biologically rooted view of marriage, often associated with most of the major religious traditions. That will still be there, but so, of course, will be the new view, newer view. I do stress it's not just 10 years old, it's a century and a half old. the romantic view of marriage, in which it refers to any two people. And I think our difficulty is constructing a legal regime which handles that fundamental tension, that difference fairly.
Notice though, in terms of the what are the
before Mr. Burrows follows his question, can I just appeal for shorter answers, please, so we'll get more questions?
And I'll invite
Mr. Burrows.
I'll invite headlines, as it were. Just in terms of what are the defining characteristics then that have permeated law up to the point where we're at? So you may say there's two views, but in terms of the characteristics that have defined the institution of marriage, what would you say those are?
The law has tried hitherto to track the more biological conception of marriage, and in that sense, that is why it has for over 1,000 years insisted that a marriage can only take place between a man and a woman. It's been a settled part of the common law, and the romantic view of marriage has been allowed to flourish, shall we say, extra-legally, through cohabitation primarily, by people who rejected marriage, and then more recently, obviously, in civil partnership as a regulated form of a freer notion, more romantic notion of marriage.
Mr. Bright.
I'm sorry, I do find that analysis hopelessly flawed and historically completely inaccurate. I mean, the 1662 prayer book provides for 3 reasons for marriage, one of which might be your romantic thing of people being able to share a mutual society in adversity or in prosperity. But before that is your procreation, and the second one is to prevent fornication and to provide for a more secure society. And I don't know whether have you ever read the judgment of the Massachusetts Supreme Court in 2003 in relation to same-sex marriages, because it makes it very clear that there's a very long history of people getting married for a lot of different complex reasons. Many of them were to do with money and property rights. So I just don't see this binary division between romantic relations. It seems to me you've created this so as to be able to argue against same-sex marriage.
No, I don't agree with that. I didn't mean to imply that the longer-standing, more biological view excluded the romantic dimension, but it insisted that several things were tied together to form a marriage, and obviously the prayer book is a classic statement of that, tying together the 3 purposes that you identified, which includes the notion of romantic love.
But until 1753, there was no, and Hardwicke's Marriage Act, there was no provision other than that a clergyman of the Church of England had to do the service. There was no other reason that it could be voided.
That is not strictly correct, because it was it was only in the 16th century that the requirement of ecclesiastical solemnization became normal within what was then the Catholic Church, the Universal Church. So actually, if you go back even earlier, it's simply by mutual consent that you can get married. But it was mutual consent between people of the opposite sex.
But I don't see how that creates your binary definition of there's one thing which is romantic love and relationships, and which, if that's what you think marriage is all about, then that's bound to lead to this. And there's another version which is marriage, which is about procreation, and therefore you couldn't possibly entertain the idea of same-sex marriage, because that's when you do end up with why on earth will we allow Prince Charles to marry Camilla?
When I talk about the older conception of marriage as being, I use the label biological, that was a shorthand for saying it attempted to be responsive to what it took to be natural facts about humankind, namely the division into 2 sexes and the involvement of both sexes in the procreation of further human beings. The concept of union there is ultimately responsive to biological unity, biological union, in that it takes 2 people of opposite sex to produce another human being. But it's biological in that broader sense, not in the sense that every single marriage obviously has to issue in children.
But a large number of the civil partnerships that I've been to do have family responsibilities, either have actual children, or they, whether surrogated or however they managed it, or adopted children. And so the care of children as a social good and as a strengthening of society, I would have thought was a third part of the value of marriage for everybody.
Yes, with respect, that misses my point. My point is that the meaning of marriage is socially constructed. We can define marriage in a number of different ways. And the question is, how do we go about doing that? and we can go about doing it in a way which attempts to track biological reality. And I'm simply recording, as a matter of fact, that has been the typical approach for centuries, not millennia. Or we can focus particularly on one dimension of a relationship, which is the romantic attachment, and we can make that the essence of marriage. We could make other things the essence of marriage as well. We could make, and many cultures do, the securing of the inheritance of property. We could make marriage into fundamentally a property-based institution.
But we might want to do all of these things, and that might point to why same-sex marriage actually adds to the greater goodness of the whole of society and can't detract from the marriage of heterosexuals.
Can I just intervene in this conversation and debate that's going on between the witness and Mr. Bryan? There's a number of other members who we wish to ask questions, and again I'll appeal for brevity in questions, in particular brevity with answers as well. Tim Lawton.
Chairman, I think it's a fascinating argument that you're putting forward, and I think your note was well argued. I just want to ask you a question on your note that you produced. You said that marriage affirms the equal value of men and women, and that was a constant theme through the note. But you said that the logic of equal recognition and radical choice means that the boundaries of any new definition will be far more vulnerable, and challenges to its exclusivity, its permanence, and even its sexual nature will be unavoidable, and because of that you think marriage will unravel. Can you elaborate a bit more on that and basically say what you think the result of going down the path of this bill will actually be?
Obviously, we're into crystal ball gazing here, and that's a dangerous exercise. I'm simply trying to follow through the logic of what I see the underlying conception of marriage to be, which is one based on romantic love and commitment, driven by a sense of individual choice. So I decide to affirm my love for an individual and commit to that individual. It's, I suppose, a fairly simple point that love knows no laws, and that if you take seriously the notion that at the heart of marriage is romantic love, then romantic love is fickle. We all know that. It changes, and so might too the nature of the commitment that we have for each other. Romantic love is not necessarily limited to one person. If you follow through the logic of romantic love, I do think you end up with actually the removal of marriage as a legal institution, ultimately. So it's not clear to me logically that marriage should be regulated by law at all on that sort of basis. And very interestingly, if you look at Soviet conceptions of marriage in the early 20th century, that was precisely the logic they followed. And marriage was not legally regulated because it was seen as a purely affective, romantic relationship between two individuals. So yes, there are lots of steps to be gone through, and I was engaged briefly in some crystal ball gazing, but I think it's a genuine possibility that we should take seriously that what we are seeing within a number of Western states right now is not simply one step which will then solve everything and everybody will be happy. It's simply the first step in a series of steps towards ultimately the deregulation or the de-juridification of marriage in its entirety.
Stephen Gilbert.
Mr. Hood, if I'm following the logic of what you're saying, Professor Rivers, you're suggesting that because lots of lesbian and gay people might want to join the institution of marriage, ultimately marriage as an institution may no longer exist.
Obviously not immediately, but I think the arguments which are used to support the extension of marriage to two people of the same sex are equally applicable in other contexts as well, and will sooner or later be used in those contexts. So the concern, if I can put it like that, no, I'll stop there.
I think, of course, Professor Rivers, you're entitled to your view, and it's crystal ball gazing, of course, as well. But it's the first time I've heard the suggestion that because lots of people want to join the club may stop existing. You said that marriage is a socially constructed concept. You were very clear that that's right, and you've also said that it's changed quite considerably down the centuries. And you posited this binary notion, which I think Mr. Bryant had some pertinent questions on. Where's the threat to marriage from two people of the same sex who love each other, wanting to experience the benefits that those of opposite sex have with an institution that everyone acknowledges brings real benefits? What is the threat?
Well, I thought I'd answered that in terms of the potential developments that might occur following on over the next generation or so. That's one threat. The other threat is the threat to religious organisations and people who wish to maintain a different view of marriage not being able to do so, when I think that in good conscience they should be entitled to their views and should be protected in law. And I think that actually is a much more important thing to focus on in terms of the bill that's in front of us.
And one very final quick question. In your biologic definition of marriage, what would you say to those couples who are heterosexual and infertile, those couples who marry later on in life, past the point perhaps where they're able to have children, those children who grow up in an adoptive family where they've been adopted by a heterosexual married couple? Are those marriages not valid under that interpretation of the binary system that you posited earlier?
The answer from within that more traditional account of marriage would be the fact that not every single instance displays every characteristic of the definition, does not deny the status of the paradigm as a central case. So you posit as your central case of marriage the one in which a man and a woman join together and produce children, and you then have a series of debates about the extent to which social forms which are more or less like that fall within the boundaries of your definition. And that debate, of course, that's one of the ways in which the law of marriage changes. So questions, for example, of whether adoption is permitted or not. That is a point on which societies differ, and at a certain point they accept adoption, and when they accept it because it looks like your paradigm or central case. So you shouldn't be thinking in terms of you're either in or you're either out. It doesn't work like that.
Ben Bradshaw?
It's my fault that I'm confused, but can we make it absolutely clear? You're opposed to same-sex marriage?
I think it is a risky development.
But you
so
also...
yeah, I think my position is that a combination of civil partnership and marriage, which reflects the difference between a same-sex friendship, partnership, and another sex marriage, is more appropriate and guards against some of the risks that I've identified.
But at the beginning you also said that this whole debate had come out of changes in the 19th century around definitions of romantic love. So didn't you lose the battle 200 years ago? And you also acknowledged that there are going to be different conceptions of marriage now and for the foreseeable future. That surely is a live and let live philosophy, as we've heard earlier, rather than your objection to it.
I don't think the battle has been lost. I think the battle will carry on. We're just seeing one more round in it, if you describe it as a battle. When the romantic notion of relationships developed, of course there was considerable opposition to same-sex relations. We know that. What has happened is a combination of society becoming more relaxed about same-sex relations coupled with a romantic notion of marriage. And when those two come together, then the proposal seems, of course, obvious that there should be same-sex marriage.
Mr. Burrows?
You said in your view that the fact of difference has to be acknowledged and valued if we are to secure equality. In terms of marriage, say securing the equal value of men and women, how do you make that point?
Well, I make that point by reflecting on whether or not marriage might be distinctive as a social institution in being one of the few cases in which the difference between men and women is both acknowledged and turned into a form of cooperation rather than acknowledged and resulting in separation or acknowledged or not acknowledged at all. So marriage is, I think, quite unique as a social institution because it expresses the cooperation of a man and a woman.
Any other questions? Mr. Williams.
Thank you, Mr. Just for the record, Julian and I obviously know each other for various constituency reasons in Bristol and know that we come to this from different perspectives, but hope we'll still be friends afterwards. Your essay, which I've read, and your daughter urged me to read it, so I have done so, you can feed that back to her, puts forward two reasons why, two arguments against same-sex marriage. One is a slightly puzzling one, that it might undervalue the equal value of men and women that is afforded by marriage. But the second one, which is what I want to ask you about, you say that marriage promotes the welfare of children rather than the procreation of children, which is usually what we hear. Do you accept that the welfare of children can be met in a variety of parental relationships, so there can be gay dads, lesbian mothers, there are half-brothers, half-sisters, stepfathers. Family relationships are complicated in modern society, but the welfare of children might actually be strengthened by same-sex marriage.
And again, I think it's important to note the nature of my argument there. There is a very simplistic argument around the impact of same-sex parenting on children, and I accept in the paper that the evidence is probably in favour of there being no detrimental impact on children whatsoever being brought up in same-sex families. So there's one little note of caution I would sound there, but that's in the paper. I think my main concern is about what a purely romantic view of marriage does to children in other sex marriages, in the vast majority. And what I would want to highlight there actually is quite simply the impact of divorce on children. We know that divorce is incredibly traumatic for children. Now, divorce, to my mind, is one of the results of the taking hold of a more romantic view of marriage. Once you fall out of love with each other, then there's no reason to stay together. And that is detrimental to children. And what I'm worrying about in that paper is the potential development and strengthening of this purely romantic view of marriage, which might have that impact on children.
Simon Kirby.
Thank you, Mr. Hood. I have to say I'm slightly perplexed by your argument, which seems to me to be a very black and white view. Shouldn't marriage be a far more multicoloured thing? It means many different things to many different people. My marriage is very special, but it doesn't mean that it should be the same as everyone's else. And doesn't the bill before us, to use your words, make space for both views? Is it not possible for those who wish to take part to opt in, and those religious groups who don't to retain their view of what marriage represents? I don't understand your argument. It confuses me.
Thank you for raising the question of the opt-in in the bill, and I would just stress to the committee that my primary area of expertise is in religious organisations and religious liberty, and I had hoped to be able to address some of those protections for religious organisations in the scope of the bill. The opt-in is, of course, one element of the lock, which is, I think, an important one and is, broadly speaking, correct. The fundamental question I had about the opt-in was the exclusion of civil partnership from it. It seems to me to be unprincipled and potentially not compliant with the European Convention to allow opt-in for marriage, but not to same-sex marriage, but not to allow opt-in for civil partnership. But that's only one of many ways in which I fear that this bill is not fully convention compliant, European Convention compliant.
Thank you, Mr. Chairman. I was going to ask you a question that wasn't to do with that area there, but do you want to expand on any aspects of that? One thing I was going to ask you is, do you feel by allowing those religious organisations to opt in, it makes it stronger in as much as it's not a blanket ban on religious organisations? I suppose the second point is, given what you've been saying about the development of different views, I mean, obviously we've heard evidence today from some religious groups whose view has developed to say they wish to carry out same-sex marriages. And if I'm allowed one observation, I'm really struggling in an unacademic way to understand how, given the long-term decline in people getting married, allowing more people to get married is going to contribute to the long-term decline of marriage. There's a question and observation.
I didn't quite catch
All right,
the purpose of your
first one was about,
question.
do you think the bill is strengthened by allowing that some religious organisations to opt in, rather than a blanket ban on all religious organisations doing same-sex marriage. And the second was just how you saw the fact that some religions wish to opt in, how that sort of fit into your view about, if you like, the historical context of marriage and the definition of marriage.
Well, I think it's just simply a matter of principle that religious organisations ought to be able to opt in. I don't think it's any more complicated than that. The question of why some religions choose to do so, religions change over time, and they modify their views of what constitutes marriage. We shouldn't think of religions as monolithic blocks. They're, of course, incredibly diverse things and incredibly fluid things. So what the bill does is, quite rightly, allow religious organisations who can reconcile their view of marriage with the legislation to opt in. I have no issue with that.
Mr. Quating.
Thank you very much, Chair. Very quickly, what provision do you think, I mean, how watertight is this bill with regard to potential challenges in courts with regard to human rights and particularly with the religious angle, if you like? You're an expert in.
I think it's almost perfectly watertight, and there are just a very few little points which I'll list in respect of the core function of marrying people. So I don't buy the argument that the exemption for the Church of England is at risk from being overturned in Strasbourg. I think the Strasbourg case law is reasonably robust, that established churches enjoy Article 9 freedom of religion rights, and that therefore if the state should choose to exempt a church, the established church, from carrying out certain forms of marriage for reasons of religious doctrine and practice, I would be very surprised if that was overturned in Strasbourg. Nothing is impossible, but that's close to impossible. I think there are a few minor worries around very much a drafting point in Clause 1. Section 17 of the Marriage Act 1949 contains the possibility of marriage in a church or chapel in which bans may be published under the authority of a superintendent registrar's certificate, and it would be worth clarifying that superintendent registrars should not issue certificates for solemnisation of marriages in churches or chapels where the church or chapel is not prepared to solemnise those marriages. So that's a minor point. It's to do with excluding Section 26E, which appears in Clause 3 of your bill, from the list there. I'm also slightly surprised to see that the government decided to deal with the issue of the church in Wales through delegated legislative powers granted to the Lord Chancellor. The reason I'm slightly surprised by
Order. I'm afraid that brings us to the end of the time allotted to the committee to